What happens to real estate without planning? So specifically real estate, and this is where title matters. So if you're watching this on YouTube, go ahead and subscribe to our YouTube channel and click the little bell. You'll be alerted to when our videos drop, and they drop about typically weekly at 6 p.m. on Thursdays on YouTube. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've been an attorney for over 30 years. I'm a certified specialist in estate planning, trust, and probate law, securities, and insurance licensed, and a pilot single-engine land. I'm not current. I'm an instrument rated. Also, I'm a real estate broker. So a broad background and a little bit of a learning junkie, if you will. I like to learn. I like to I'm very inquisitive, learn new things. And we revisit old topics like intestate succession, because we have a lot of lawyers at our firm. We're here to help people, and people do come in and they say, gee, well, what happens if I don't do anything? What happens if something happens to my kids and they don't do anything? Or what happens, my parents passed away and there's no will. What do we do? So we have 18 attorneys now dedicated to all things peaceful transfer of wealth from one generation to the next. So that is a fun area of the law for us. This is a disclaimer, very, very important. This is not legal advice. This is information. These videos on our YouTube page, we now have well over 200 videos. These are designed to educate the public at large. This is not a substitute for legal advice. There are a lot of different ways of holding title. And if you're buying real estate and in California, and you're typically, you're going to go through an escrow company and a title company. If you're married, there are 9 different ways to hold title in California. If you're single, slightly less, but a lot of different ways. And I remember when my wife and I bought a home a few years ago, I was like, wow, there are 9 different ways. I forgot about this, right? Because it's been a while since we bought a piece of real estate. So there are different ways to hold it. We're going to go through each one of these. So individual or sole owner. So that is if Jim owns the house, I have the sole right of possession. It's in my name. I can convey that property, right? There's no restriction on it. And then whoever the purchaser is becomes the owner of that property. And in the Anglo-American system of property ownership, I cannot put restrictions typically on those deeds to say, well, this can only be sold to someone whose name is Jim and whatever. It goes to that subsequent purchaser. And then at my death, if just my name is on title to the property, that is subject to my will. So even if I have a living trust, this property never made it into my living trust and there was no assignment to my living trust and it's in my name, my will would leave this property to my living trust, and that would require a probate. And if there is no will, then it goes to on intestate succession. And then the court needs to determine, because I have children and I'm married, what portion of this is separate, what portion is community. And then we may end up having 2 proceedings, one proceeding to get the property to the spouse and another proceeding to get that property to the children. So the interest can be creditors. If I have creditors, they can seize that property and the creditor can become an owner. And then the presumption that the property is owned by the living trust. When we put it in the living trust, when it's my name as Jim, as trustee of the trust, then the presumption is that it is in the living trust. So again, we're talking about intestacy. This is in part designed to talk to people who are thinking about doing estate planning. And by doing an estate plan, you can, if you put that in a living trust, you can keep it out of the probate. So Oscar owns Blackacre. Oscar dies with a simple will. Victor's name as executor and sole devisee heir of Oscar's will, and hires Cunningham Legal. So Victor hires Cunningham Legal to represent Victor in the probate court. And 16 months after hiring us, the probate court the probate proceedings concluded, and the court orders that the property be distributed to Victor. And so what Victor does is he signs a deed, a personal representative deed, transferring that property from Victor as executor of Oscar's estate to Victor, an individual. And so now Victor is now the sole owner of that property. Now, what Victor should do is he should think about doing a revocable living trust centered estate plan so that when he dies, that property doesn't have to go through probate again, right, for the family. So community property, only spouses and registered domestic partners. And again, I would say state registered domestic partners. Before there was a statewide registered domestic partner procedure. People did it through certain municipalities. San Francisco and Oakland were a couple of them. Some counties did it. And so now I would say if you are not a state registered domestic partner, you really need to look into that because if you're a registered domestic partner, you want to make sure you have that nailed down. And that's kind of a topic for another day, but just something to pay attention to. Equal ownership and managerial interests. So if my wife's name is Lori, if Jim and Lori own the property as community property, that is the community owns the property. I have an undivided interest to the whole, and my wife has an undivided interest to the whole. That's how it is. The management is unified and it's equal. It's equal management. Any transfer requires written consent of the other spouse. So this is why you might see. So if I own property just in my name as Jim Cunningham, and then I go to sell that property to you and I'm married, the title company is going to require a quitclaim deed from my spouse. Okay. This is why sometimes you see these quitclaim deeds from spouses, a quitclaim deed from the spouse to either me or to the buyer, right? Because they want to make sure that I'm not, because I can convey my portion of the community property, but then if she doesn't agree with it because she has equal control, even though title's in my name, that's why you might see that quitclaim in there. I know it's a little granular, but that comes up quite a bit with clients. Again, one spouse can own 100% of the community property, meaning it's in the spouse's name, not in the other spouse's name. And on death, if the property is owned in the deceased spouse's name, half goes to the survivor, right? So if I die with a property that is community property just in my name, half goes to my wife, and then half is distributed under my will, which says it goes to my wife, so she gets it all. The successor status is tenancy in common. So if I left my half of the community property to my 3 kids, my wife would be a tenant in common with her 3 kids because we share those kids together. So that would as how the successor looks. Creditors do have rights, liability for debts of either spouse. Title determines outcome at death, but not divorce. So this is where it gets a little tricky. We'll talk about this with joint tenancy. This is where it can get particularly problematic if you have joint tenancy with a non-spouse and you're married. So Oscar conveys Greenacre to Abel and Baker, spouses as community property. Abel dies without a will under California's laws of intestate succession. Baker inherits the property at death because Baker is the surviving spouse. Abel could leave Abel's half of the property to anyone by will. So Baker hires Cunningham Legal to initiate a spousal property petition in the county of Abel's California residence, not necessarily where the property is located. And then we guide Baker through the process. And after one probate hearing, Baker then owns 100% of Greenacre. So that's how the process works. Community property with right of survivorship keeps you out of probate court. At death, the interest passes to the survivor, and the right of survivorship may be terminated, so unilaterally by one spouse, but it can only be used when 100% of the property is owned by the community spouse. So you can't have like the community property with right of survivorship on a third and then another person, or 2/3 and another person owning a third. Creditors do have rights, so some creditor issues there. And then survivorship must be expressly stated. So community property with right of survivorship. And then so in our case of Abel and Baker, Oscar conveys Greenacre to Abel and Baker, spouses as community property with right of survivorship. Abel dies without a will. Because of the title, Baker inherits the property at death because Baker's the surviving spouse. Baker hires Cunningham Legal to prepare an affidavit. So this is not a court hearing. It's an affidavit that's recorded with the county recorder where the property is located. And then we guide Baker through the process. And after recording the affidavit, Baker then owns 100% of Greenacre, Baker's name, and is sole owner without having to go through probate. So if you're choosing between community property and community property with right of survivorship, that's the difference, is you don't have that court proceeding. Now, that may be a good thing. It may not be a good thing, depending on what your estate plan says. But I would say for most of our clients who have a living trust, they're not doing community property with right of survivorship. They're just putting it in the trust. Joint tenancy, any number of human beings with heartbeats can be joint tenants, but they must be human beings. Equal ownership interest, you can have halves, thirds, quarters, fifths, but it's all equal. And they all have to go on title at the same time. They all have equal right of possession. And the transfer severs the joint tenancy as to that joint tenant, and the new owner becomes a tenant in common. So if you have 3 people in and one person conveys their interest, that new third person coming in is a tenant in common. So the other 2 do not get that new third person, right? That new person, and they're not going to inherit that by survivorship. At death, the interest ends. So it's the last man or last woman standing gets the property. and the creditors have rights, and they can force a sale of one of the joint tenant owners. So if you three people go in on a house and one's got some creditor issues, that creditor can force a sale of the entire property. And it must be expressly stated as joint tenants. Now, Texas, joint tenancy has to say joint tenancy with right of survivorship for there to be a right of survivorship. So that's not the default. California's default is a right of survivorship. Oscar conveys Blue Acre to Charlie, Delta, and Echo as joint tenants. Charlie's unmarried and dies with a will and living trust that leaves everything to Charlie's children. Delta and Echo still inherit the property because that joint tenancy property was never funded into the trust. So the full value of the joint tenancy property is included in Charlie's estate for estate tax purposes, unless it can be proven that Delta and Echo contributed money, so that there's a burden shifting there. And there's a 1/3 adjustment in cost basis at Charlie's death, meaning Charlie's his third interest, the step up in basis to the fair market value that helps Delta and Echo potentially with some capital gains taxes. But Delta and Echo own the property. Tenancy in common is any number of persons, living and dead humans, LLCs, partnerships, corporations. So joint tenancy, human beings with heartbeats. Tenancy in common, you can have non-human persons. And it sounds weird, a non-human person. A little bit like, I forgot the guy's name who was running for president. Mitt Romney talked about corporations are people too. That's what we're talking about here. These can be equal or unequal. It can be 90-10. It can be 50-50. It can be whatever you want, but the numbers should add up to 100. You want to check your math on that. Separate legal title is to undivided interest. So it is an undivided interest, meaning you have the right to the whole. Equal possession, if you're on there for 10%, you have a right to occupy the whole, even though you're only entitled to 10%. So if it's 10 acres, you're not going to be confined to 1 acre. You can roam around all 10 acres. Each interest must be conveyed separately. So not meaning you can add someone as a tenant in common. So if I own the property 100%, I can convey 10% to somebody, and now we're 90-10. That's tenants in common. That is not joint tenancy. At death, the interest passes by will, and heirs become co-tenants, okay? So, and putting heirs in quotes, because if you have a will, technically it's the legal term is devisee, not heir. Heir means literally there is no will and you are an intestate heir. But again, if you're a co-tenant with other people, you're going to end up being partners with whoever inherits their portion of the property. And there is a presumption of tenancy in common in doubtful cases. So if it's a little ambiguous, the default is tenancy in common. So if someone tried to do joint tenancy, so let's say I have a property and then I transfer a property to a portion of the property as joint tenants, or it's like 90-10 as joint tenants, you ignore the joint tenants and it will be tenants in common. So remember, joint tenants has to be equal. Oscar conveys Red Acre to India, Juliet, Kilo, and Lima, LLC. So 3 people in an LLC as tenants in common. India dies with a will. So one of the humans dies with a will. Mike, India's son, is named executor and sole devisee or heir under the will. And he hires Cunningham Legal to represent Mike in the probate court to admit India's will to probate court. 16 months after hiring Cunningham Legal, the probate is concluded, and the 25% interest in Red Acre that was part of India's estate is ordered by the probate court to be distributed to Mike. And then we prepare a deed for Mike to sign, a personal representative deed that transfers it from Mike as executor of India's estate to Mike, an individual. Now, Mike owns 25% with Juliet, Kilo, and Lima, LLC. Juliet, Kilo, and Lima, LLC may never want to be partners with Mike, but they are partners, right? They're quarter interest, and that's how it works. Change in ownership. This is very important for Prop 13 taxes. When there is a change in ownership, property is reassessed. Death is a change in ownership. Let me repeat that. Death is a change in ownership. Now, if you're a spouse or surviving registered domestic partner, transfers between spouses and registered domestic partners are not changes in ownership. Just that statutorily, that is not a change in ownership. I know it sounds a little weird, but the property is going from one person to another. But apparently that's not a change in ownership because of the legal status of the deceased person when that event happened, when that death happened. So if Owen sells Green Acre to Abel for $1 million, obviously a sale is a change in ownership, right? I'm going to give you Green Acre, you give me $1 million. That's change in ownership. Owen leases Green Acre to Abel for 20 years with 3 5-year options. That is a change in ownership. Long-term leases are a change in ownership. If it's over 30 years, a change in ownership, and then mom gives the family home to daughter or sells it for $1 to the daughter, that is a change in ownership. Certainly when mom passes away, it's a change in ownership. When there's a change in ownership, property is reassessed. So Prop 13, very important, valuable property right. This is highly relevant when it comes to intestate succession because many times people will say, well, mom died 10 years ago and we haven't done anything. There was a change in ownership 10 years ago. That property gets reassessed at death unless an exclusion applies. And sometimes they'll let you file a late exclusion, but there still might be some back taxes in there, right? They still might reassess you for a period of time. So Prop 13 passed in 1978. What it did is it amended the California Constitution. It rolled back property assessment levels to 1975 levels. People used to pay 2.6% on average of the market value of the property in tax. Then it got cut to 1% of assessed value. Assessed values can only go up 2% a year. So if you bought that condo for $25,000 in 1975, your property taxes are probably under $1,000 a year, right? If someone buys that condo today, their taxes are $6,000. We'll have a slide on that. So they're a lot more for newer buyers, right? So if you have had real estate for a long time, you understand that. If you've had property a long time, you know, if mom's had that property a long time and then mom dies, that property's going to, especially now with Prop 19 that took away, broadly speaking, the parent-to-child reassessment exclusion, you're going to have a tax reassessment in there. So it's something you need to get your head around. It means you're going to inherit less money and then more money's going to the county for property tax. So property's fully reassessed when there's a change in ownership. And we've got an example here. We've got 3 families. So these are condos in Todd Ranch in Ventura, where I spent some of my childhood. Grandma and grandpa bought their condo in 1975 for $25,000. Mom and dad buy their condo in 2000. And then daughter and spouse buy their condo in 2025. Each condo is 1,449 square feet. They're exactly the same. They're 3-bedroom, 2-bath. They are different taxes. So grandma and grandpa's assessed value is $67,000. Mom and dad's is $200,000, and the daughter's is $600,000. So same exact condo. I mean, in law school, they told me every piece of property is unique. I don't know about these condos. They look one looks kind of the same as the other. But look at the difference in property taxes, under $700, $2,000, and $6,000 for the same property. So if the grandkids are inheriting the parents' condo and they go, oh, well, the taxes are only $673 a year, they might bump up to $6,000. So you've got an extra $5,500 in a year to pay in tax. So it's just something to get your head around. So what happens to business assets without planning? I can tell you it is not pretty. So title, if title's in an entity, a partnership, LLC, or corporation, meaning assets are owned by a corporation, and then the person who owns these shares of the LLC or owns the business passes away. So we have to look at a lot of different things. Not only do we have to see if there's a will, we also need to look at the operating agreement or the bylaws or the buy-sell agreement or the corporate documents. We're going to have to take a look into those. I would say a lot of probate practitioners aren't as strong on the corporate side. Traditionally, the trust and estate people, I would say a lot of times they stick to, they kind of limit the scope of their practice to non-corporate matters. The corporate practice tends to be an additional subspecialty. And in our firm, we happen to do both because we're a little bit larger. We can handle both the estate stuff and the business as well. We've got attorneys in both camps. So you do need to look at the operating agreement on the LLC, and also what are the rules? Who can be admitted as a member? Maybe the intestate heir. So if you're a manager of an LLC and one of your members dies, you need to look at that LLC document, because the other partners may say, you know what, we wanted Jim as a partner, but gee, we don't want Jim's spouse because that spouse isn't really bringing any value, and Jim was a real integral part to this. So we'd rather just cash the spouse out. So these are some of the things. This is not just something where if a person succeeds to the property like they do as a tenant in common, right, where they just automatically become an owner. There's no automatic becoming an owner when it's a business entity. So without planning, the business assets are likely going to be subject to probate court, which is that court supervised process. It's lengthy. I will tell you, probate judges don't know nearly enough about the business that's going on as they should. But they're busy people, right? They're handling a lot of different matters. So that's why you appoint an administrator or an executor to handle that. Still, it's court supervised. Accounts are often frozen during the probate process. This can be really difficult if you have to meet payroll. So this happens frequently. You get the panicked call, maybe from a surviving spouse, maybe from a child, saying, look, we have to make payroll and there's no one who has access to the checking account. We need to go in and get emergency authority from from the court in order to make payroll, right? In order to pay people, and that's pretty important, right? Got a lot of people relying on getting paid. The day-to-day operations often suffer because there's no designated individual to take over. So if you have a business, you should have a buy-sell agreement, some type of succession plan. If you're not there to do and act on behalf of the business, then you really need to have somebody in there who can act on your behalf outside of the probate court, right? So this is about estate planning. In many instances, the business is sold or liquidated. If you're a dentist, that dental practice must change hands within 30 days, or by law, it must shut down. So this is a carve out for dentists because you're holding on to apparently a lot of drugs. I mean, I think that's basically it. It's a DEA thing, I think. You have to have that business, that dental practice transfer to a successor, or it is shut down. So we learned that when one of our clients passed away suddenly, who was a dentist. So John, the owner of a successful family-run manufacturing business, unexpectedly passes away without a succession plan, and chaos ensues. His heirs are thrown into a probate court battle, each with conflicting ideas on how to manage the company. Operations are stalled, and no clear leader emerges. This causes key clients to do what? They're taking their business elsewhere. They're out of there. Employees are worried about job security. They start leaving. They start looking for new employment. And really, the business is sold for peanuts to pay its debts, and the family legacy crumbles, and legal fees mount, and the personal relationships are fractured, leaving a once thriving business in ruins. This does happen, and it's sad, frankly, because with a little bit of planning, I think a lot of this can be avoided. So how can intestate problems be avoided? Let's talk about avoiding them. Hint, it's savvy estate planning. So an estate plan involves a living trust, a pour-over will, typically a durable power of attorney for property, durable power of attorney for healthcare, HIPAA authorization, deeds to the properties. We covered this in other videos, and I would encourage you to take a look at those, how to craft an estate plan. So a living trust is a lot like a bucket. So you create this bucket, it's got a handle. The trustee holds onto the handle. The trust itself is this bucket. I mean, obviously trust is a document. It's not a bucket, but I'm trying to help you out here. You put your house, stocks, bonds, mutual funds into the bucket. IRAs, 401ks, life insurance, annuities stay outside of the buckets, out of the bucket. All trusts have a trustee, a beneficiary, and a corpus or stuff. So a trustee is a person who's holding onto the handle. You've got the bucket. While you're alive, your living trust, you're the beneficiary of that, right? You might be the trustee holding onto the handle. You're also the beneficiary. But if you stop being trustee, let's say you're not dead, but maybe you have a stroke, that bucket then passes to your successor trustee, that person drops the term successor. They become the trustee. You're still the beneficiary. So those assets are used for your benefit. And that's really how it works to keep you out of probate court. That does not require court intervention. And it's a much more effective way of managing your estate than relying on the probate court system, which is really kind of the last resort. So trusts take care of your assets while you're living. They avoid probate at death. There are little used strategies, broadly speaking, with other lawyers that we use a lot in our firm to protect assets when those assets pass to your heirs from their divorce, taxes, and lawsuits, the creditors, predators, and divorce. And a revocable trust typically becomes irrevocable or irrevocable at death. So a revocable trust can be amended during lifetime. An irrevocable trust cannot be amended. So we have an example here. If you're watching this on a video, we have Abel and Baker. They create a living trust, the Abel and Baker Smith. They create the Smith Trust dated April 10, 2025. The trustees are Abel and Baker. When Baker dies, all of Baker's assets go to Abel. Then Abel dies, and then there is what we call trust administration. Both when Baker passes away, the first passes away, and then when Abel passes away. What is trust administration? It's where you pay debts and expenses, and you remove a deceased person's name from assets. You might value the assets, right? Because you get adjusted cost basis. So that stock that you paid a little bit for that's now worth a lot. When Baker dies, Abel, if it's community property, Abel can sell that stock and not pay any capital gains taxes. Pretty cool. And then once Abel dies, we go through trust administration again and make distributions to the children. The benefits of a living trust: avoids probate, avoids the hassle, delay, expense of probate, maintains privacy. This is something, 30 years in practice, I'm valuing more and more is the private nature of estate planning. We're awash in information in the world, and it's only getting more accessible as time goes by. And think about it: the date a person inherits, the amount they inherit, their address, Sometimes their phone number is all a matter of public record. And so that's something where a lot of people want to keep that private for a lot of different reasons. And really, the living trust helps protect your legacy in a way that a will simply doesn't, or no plan doesn't. So living trust definitely one better way to go. So I'm a parent. We've all been there. Our adult children may be dragging their feet with adulting. So health insurance paperwork, oil changes, job applications, getting your retirement account set up, going to the dentist. I mean, if you have kids who are, maybe out of school and not quite fully launched, they're in maybe their 20s, maybe 30s. Many younger adults have not created basic estate plans. Life's unpredictable. Accidents happen. Stuff happens. I would say that if you're a parent of adult children, your adult children should consider doing estate planning. Now, it may be just a will. Like if they don't have much assets, right? If they only have 100,000 in assets, maybe a will's enough. Certainly the durable power of attorney for property management and personal affairs, and the advanced healthcare directive. Probably the most important one is the advanced healthcare directive. That's something we can provide in our office. It's also readily available for download for free, right, in California, where you can download the California statutory form power of attorney for healthcare. That's something you really want to have your kids look at and name somebody, whether it's you or a sibling or somebody else. It's something they should have, because you won't have access to their health information if they do have a health emergency. So Emily, a 28-year-old single mother, thrived on adventure. Her weekends often spent skiing in the Rockies. One morning, a tragic skiing accident leaves her in a coma. Without an estate plan, her 8-year-old son, Jake, faces uncertainty. Who's going to care for Jake? He's 8, right? Under the laws of intestacy, the biological parents often have presumptive rights to custody. So that may be a good or bad thing, right? So it could be Jake's father, who he's never met. Decisions about Emily's medical treatment and life support fall to distant relatives unfamiliar with her wishes, right? What if they withdrew life support? Her assets intended for Jake's future are going to be stuck in probate, and other family members might try to claim a portion of the estate. So for those reasons, Emily, certainly if you have an adult child with children, really do need to look at estate planning. Again, whether it's a will-based or trust-based, kind of depends on the amount of assets, but thinking about having your adult children do estate planning, designate who inherits. You may not want to inherit from me. I know this is kind of weird, but I have multiple kids. I'm not sure if one of my kids died, I would want it going to my wife, and I would probably want it going to their siblings. Well, the child can do that. They can say, I'm going to leave it to my siblings, not my parents. Also appointing decision makers for healthcare power of attorney, advanced healthcare directive. Avoiding probate, obviously very important, but making medical decisions, super, super important. And this can prevent family conflict, although sometimes family conflict is just going to happen. I get that. It can make managing a crisis more manageable. So you're empowered as a parent to make typically healthcare decisions for that person who needs those decisions made. So what sort of nudge? How do you nudge your kids on doing this? Parenting's kind of an interesting thing, right? And one thing is they could just watch this video, so it's not you telling them. But starting a conversation, maybe within capacity planning, it's a little bit less intimidating. So what happens if you get hurt and I can't tell the doctors what you want? I would frame this as empowerment, control, give your child agency to make their own decisions. This is not you telling them to do something, but it's you enlightening them, saying, look, if something bad does happen, you have the power to designate who makes these decisions for you. And really, it's your child's decision. If they're an adult, fully competent, it's their decision, but they should write it down. It should be documented. And, accidents happen. Some people say, I don't have enough assets. Well, you're planning for just more than assets. The other thing too, is sometimes we create an estate plan that gives something to kids either now or in the future. And those children should, certainly if you're creating maybe a more complex plan as a parent, you're going to want to have those children create the estate planning documents necessary to not make your estate plan disruptive if they die and you may still be alive. So I know that's kind of cryptic, but a lot of our clients do set up structures where they are making lifetime gifts to their children, where the parents still control it, but these clients essentially have an equity stake in some of the parents' assets. Well, you want to make sure that that's nailed down. And so your child doesn't leave it to somebody that you don't want them to leave it to. You need to have that conversation. And so many times when clients do a more complex estate plan, typically for a higher net worth client, we're also doing estate planning for the children as well for those reasons. But again, even if you don't have that, they still have the medical issues. I don't know where to start. We can start with an initial consult. It's too expensive. things are expensive or things are costly. You know, it's expensive, frankly, if it's a waste of money. It's costly if it's not. Sometimes people just pay for it, right? You can give them funds to pay for it. You can have a third-party payer agreement. So you can say, hey, go see Cunningham Legal. I'll foot the bill. And then we have an agreement where the child is the client and that the attorney-client relationship attaches to the client, but the parent is paying the bill, and that would be called a third-party payor. So that the ethics rules say that just because you're paying as the parent, you're not the client, and we maintain the confidentiality with the child. So an estate plan, again, is a living trust to pour over will, durable power of attorney, HIPAA authorization, advanced healthcare directive, typically deeds to your real estate, as well as beneficiary designations on IRAs and 401ks. That brings us to the end of our content. We have office locations in Northern and Southern California, many lawyers to serve you. We're all about the peaceful transfer of wealth from one generation to the next. The next time we are meeting, April 24th, the topic is small business lawyer. Do you need one? Do you have a small business? Are you thinking about a small business? Do you need a lawyer? We're going to cover when and whether you need a lawyer for your small business, and you can register on our website. Please subscribe to our YouTube channel, and we will open it up for questions now. If you're watching this on YouTube, by the way, if you've made it to the end and you're on YouTube, please sign up for one of our webinars because I'm about to answer questions live. And a lot of people, they put a lot of questions on there. It's your opportunity to ask me questions without being charged for it. So kind of cool. But if you're watching this on YouTube, keep watching, and we'll see you next time.